So it's really about your present state at the time, and if you're able to understand the proceedings in the court.
The next twist, in the case of 16 children removed from an Ohio home, may come from their father, who's
The public record is stark. 16 counts of child endangering, serious physical harm, children removed from a home described as disgusting, but the next document filed with the court doesn't argue the facts of the house. It argues the state of one man's mind.
Gary Cers Jr. faces 16 counts of child endangering. His wife, Elizabeth Cers, faces the same charges. Gary Jr.'s parents, Gary Cers Sr. and Christina Cers, face the same charges. All four have pleaded not guilty. Now,
Gary Cers Jr. faces those 16 felony counts. The charge explicitly states the children were abused and that the abuse resulted in serious physical harm. The mechanism of justice is now set in motion, but a single motion from his defense attorney is threatening to stop that mechanism cold before it ever reaches a trial.
he has a lawyer, and that lawyer is planning to ask the court for a mental health evaluation to determine whether Gary Jr. is fit to stand trial. Attorney R. Lee Roberts has filed a motion asking Judge Rogers to allow him to file a...
Think of a door inside a courthouse, not the one the public walks through, but a side door marked for records. The attorney for Gary Cers Jr. has asked Judge Rogers to lock that door. A motion for a competency evaluation has been filed, but the request is not just for an evaluation. It is a request to file the reasons for that evaluation under seal, hidden from public view.
The documents at issue concern defendant's present mental health condition and requests for psychiatric examination. These documents contain highly sensitive mental health information or information directly reflecting defendant's psychiatric condition.
The filing states that the documents concern the defendant's present mental health condition. They contain, quote, highly sensitive mental health information. The argument is that public disclosure would unnecessarily invade the defendant's privacy. So the question of whether this man understands the charges against him will be argued in the dark.
Defendant does not seek to seal the entire case record, but only the competency motion, proposed entry that disclose or concern defendant's mental health condition and competency evaluation. No less restrictive alternative would adequately protect the confidentiality interests at issue because the substance of the filing itself concerns defendant's mental condition and need for evaluation. Good cause, therefore, exists.
He does not seek to seal the entire case. Only the material that reveals his current psychiatric condition. The legal standard is that no less restrictive alternative exists. The substance of the filing itself is the secret. The paperwork already knew.
He's accused of exposing himself to someone on 4 occasions between May 23rd and May 31st at the home on Omer Street. The complaint says the person Jr. exposed himself to was not a family member. Now, this may be part of the reason this competency issue.
The competency question bleeds into other charges. Gary Jr. also faces 4 misdemeanor counts of public indecency for allegedly exposing himself to someone outside the family. That case just got a continuance. The delay is not about a scheduling conflict. It is about whether the man accused can even participate in his own defense.
Answer that question for us. He's a forensic psychiatrist and performs competency evaluations. Thanks for joining us, Dr. Bober.
Great to be here.
Talk to me, if you would, a little bit about, first of all, this request. The attorney for Gary Cers Jr. is raising competency as an issue. Does that surprise you?
No, it doesn't. In the state of Ohio, people are presumed to be competent, and competency can be raised by either the prosecution, the defense, or the judge themselves. So in this particular case, what we're looking at is the defendant's present state of mind. Distinguish that from their state of mind during the commission of the crime, which would be a sanity evaluation. And so we're looking at a two-pronged test. We're looking at if the defendant is able to understand the nature and the objectives of the proceedings against them, and they're able to assist in their own defense. So if they are deficient...
Here is the legal framework. Dr. Daniel Bober, a forensic psychiatrist who performs these exact evaluations, explained the two-prong test. First, can the defendant understand the nature and objectives of the proceedings? Second, can he assist in his own defense? If he is deficient in there, he is deemed incompetent. This is not a judgment on what happened inside that house. It is a judgment on what is happening inside his head right now.
All true. And it's important to note that even if you are suffering from a psychiatric illness, for example, schizophrenia or bipolar disorder, that doesn't per se mean that you will be found incompetent. So it's really about your present state at the time, and if you're able to.
And here is the critical distinction. Even a diagnosed psychiatric illness, schizophrenia, bipolar disorder, does not automatically make someone incompetent. The law asks a narrower question. In this moment, sitting across from his attorney, does he know what a prosecutor is? Does he understand the role of the judge? Can he follow the proceedings and make decisions about his own fate?
And the judge, of course, understood that and entered a not guilty plea on his behalf. So that right there shows me that he understood enough to actually ask for a lawyer. He wanted to consult with an attorney. What does that tell you about his potential competence here?
I don't know if we could draw too many conclusions from that. I mean, he may have known enough to know that he knows what he doesn't know, and he needs to ask an attorney. If he were...
But a strange thing happened during Gary Jr.'s first court appearance. When the judge began to explain the possible pleas, Gary Jr. interrupted. He asked to speak to a lawyer first. That single request complicates the narrative. He knew enough to know he did not know enough. A man who cannot function does not typically pause proceedings to demand counsel.
But potentially restorable, he would be committed to a psychiatric hospital or some outpatient facility where they could try to restore his competency and potentially receive involuntary medication. And generally, with serious felonies in the state of Ohio, that could be up to a year. If he's incompetent but not restorable, then at some point he may be committed civilly to a psychiatric hospital if the court believes that he's guilty of the crime by clear and convincing evidence and he's still a danger to the community. He could be committed to a psychiatric hospital up till what the maximum sentence would be if he were to be found guilty of the crime.
Mm-hmm.
If the evaluation finds him incompetent but restorable, that can commit him for up to a year to restore his competency, possibly with involuntary medication, if he is found incompetent and not restorable. And if the court believes by clear and convincing evidence that he committed the crimes, he could be committed to a psychiatric hospital for up to the maximum sentence. The trial never happens, but the confinement remains.
Do defendants ever feign incompetency during an evaluation or fake it or try to exacerbate symptoms?
Yes, and very often psychologists will use instruments to detect that malingering or feigning that you're describing, which is not uncommon.
The system knows defendants can fake this. Psychologists deploy instruments specifically designed to detect malingering, the clinical term for faking symptoms. The test doesn't just measure mental state, it measures authenticity. A man accused of hiding 16 children from the world is now being tested to see if he is hiding his own capacity.
Okay, so in all honesty, I'm not surprised because when you examine the facts of this case, this is like no other case I think we've analyzed in my career. Like, this is a really strange case with the level of neglect that went on with so many children for so long. Now, here's the one thing that I think our viewers have to keep in mind. A competency hearing or a competency determination is not the same as insanity. And a lot of people will confuse the two. So competency, why?
Criminal defense attorney Jana Spilbor analyzed the logic behind the motion. She called it a really strange case. The level of neglect with so many children over so many years stands apart. The competency question makes a specific kind of sense. It asks whether the man sitting in jail today understands what a court proceeding is. Not what he did. What he can do now.
That indicates this defendant had deficient mental capacities. And now here we are facing several felony charges. And does he get it? Does he know where he is? Does he know what a court proceeding is? Does he understand what he is charged with? Does he understand what he's done? And so it does make sense. And I am not surprised by the current motion on his behalf.
The short leap the defense wants the court to make is this. If the living conditions were this extreme for this long, perhaps the mental capacity of the adults was always deficient. And if it was deficient then, what remains now? Does he get it? Does he know where he is? The law separates the crime from the competency to be tried for it. The public struggles to do the same.
Years ago, we've got 16 kids ranging from infant to 8 months to 18 years that's a long time to live in that kind of squalor. And here's the one thing I will tell you that bugged me. I said to myself, well, he must be competent because this family knew how to evade detection. They knew how to hide. They weren't in school. How were they living? Nobody applied for social services. Do you do that on purpose so that you can live like wild animals? I'm sorry to say it, but that's kind of how they were.
But the record contains a paradox. This family knew how to evade detection. For years, 16 children were kept off the radar. No school, no social services. Only one truancy complaint in a neighboring county, filed back in 2021. The system was avoided with precision. That takes planning. That takes an understanding of consequence. And now the same man is asking the court to find he cannot understand the consequences he faces.
They couldn't write their name. I mean, this is just years and years of not being raised as we all socially are normally. And it's really, really sad. So in this case, there has to be something going on. So the competency issue is one thing. And if he is found incompetent, that doesn't mean it's, game over. That means they'll work on him to get him competent. And then the case can come.
The reports from inside that house are grim. Children who could not speak. Children who could not write their names. Years of isolation so complete that basic socialization never occurred. The competency evaluation will not address any of that. It will ask only one thing. Can the man who presided over this isolation now sit in a courtroom and assist his lawyer? The paperwork already knew.
His father, Cers Sr., they've raised that issue with his father because he seemed really out of it at his initial court appearance. So I'm wondering, are we going to see this raised in the other cases? Because, Jonna, we're really at the complaint phase of this case where they've waived their preliminary hearings. Mm-hmm. We haven't even seen an indictment yet. We don't know what charges that will be indicted at grand jury and presented and requested at grand jury.
The father, Cers Sr., is already undergoing his own competency evaluation. He appeared visibly unable to follow his arraignment, an elderly man with a serious medical condition. 2 generations of the same family now being measured against the same legal threshold. And the prosecutor is still deciding what charges to bring before a grand jury. The indictments have not even been written yet.
Big question. And I will say something that I find really interesting about this. Again, nothing about this case warms my heart. Do not get me wrong. But here's when I look at it and I say, okay, these are real. This is horrible. The conditions are just, I haven't seen anything like this. But the one little tiny saving grace for the adults in the room is that they all seem to be living that way, as opposed to cases where you have, parents that are, eating, filet mignon, and the kids are the ones who are being malnourished and are not getting the care that they need. This whole family was living just like they were cave people and worse. So to me, that might be something that
Here is what cuts against the obvious rage. The adults lived in the same squalor. This was not a case where parents dined well while children starved. Every person in that house was living in the same conditions. A defense attorney might argue that points not to pathology, but to a shared pathology. The tragedy has no villains who lived comfortably while others suffered. The tragedy is that no one was spared.
Yeah, it's astounding. It's stunning, and we're still waiting for more answers because at this point, we certainly have more questions than we do answers. I mean, the only update we have on the children is that they're in therapeutic foster care. We don't even know their exact conditions, and maybe we shouldn't know that as the public because it's health information. It's protected by HIPAA, but it would be nice to receive some sort of update on how the children are doing. And I'm sure you can agree with that as well.
It's going to be such a long road for these kids, and probably even worse for the older ones. I think the oldest is 8.
The children remain in therapeutic foster care. Their exact medical conditions are shielded by privacy laws. The oldest is 18. If that child spent an entire life without reading, writing, proper nourishment, or socialization, the damage has already been etched into bone and brain. The younger ones have a chance, but only if the system moves faster than it has so far. So what happens when a house full of secrets collides with a courtroom that wants to seal the last of them? The paperwork already knew.
Jr. remains in the Southeast Ohio Regional Jail on a $300,000 bond. His wife, Elizabeth, The mother of the children and his mother, Christina Linsiders, also remain in jail. Their bond is also $300,000.
Gary Cers Jr. remains in the Southeast Ohio Regional Jail on a $300,000 bond. His wife and his mother are held on the same amount. Gary Sr. is out for medical treatment, his own competency in question. 4 adults, 16 charges, and not a single trial date set.
We're going to keep a close eye on this and let you know what happens. That's it for this episode of Crime Fix. I'm Anjanette Levy. Thanks so much for being with me.
Go read the motion to seal filed by attorney Arlie Roberts in the Vinton County Court. Ask yourself one question in the comments. Is a competency evaluation about protecting the defendant, or is it about protecting the rest of us from what the defendant might finally reveal? We will be here when the seal is broken.